Initially it was like, oh my gosh, what did I get myself into? But I think I'm loving it so far.
Learning all the technology, huh?
Yeah, that's another thing too, right? It's like developing new skills and you're like, well, I think I like it.
Yeah.
Awesome. Okay, so we're live on Facebook. Will also be recording for replay purposes. And I'm just going to share this on my own Facebook as well. So let's see before we continue. It's all tech stuff, guys. Just setting out all the tech stuff. Okay. I think we got it. Okay, shout out to my timeline. Donna, you're not on Facebook, are you?
Kickstart Law is, yeah.
Yeah, I know Kickstart Law is, so I tagged you on there, but I'm not sure you have any personal Facebook.
I do, I just don't pay attention to it.
Okay.
I don't log in very frequently.
Not like many of us. Okay. So one more last thing to start out, and then we'll just get started right away. All right, awesome. Okay, so we're live today. It's Monday, April 20th. It's 10 a.m.-ish. And I'm Caroline Latano. Today I'm talking to Don Dings of Kickstart Law, and we're going to be answering questions about everything commercial leases, employee issues from a legal perspective. Basically, just ask Don Dings any legal questions that you have surrounding COVID-19 and how it relates to all of these issues. I'm sure there's so many questions. Before I go on and introduce Don and then we dive into the questions, I just want to say today that any information that's provided during this conversation is only general legal information, and it's not intended to be relied upon as specific legal advice, and that there is no solicitor-client relationship created through this forum. If you want to book a consultation with Don after this conversation, that is absolutely possible. You can book a free consult with Don. I believe Don is giving 30 minutes free consultation with questions that are regarding questions and issues regarding COVID-19, and she'll be happy to answer your questions. I will put up her information towards the end, so you want to wait and stay tuned for that. Okay, so let's get started right away. Hi Don, how are you today?
Hi, Caroline.
Awesome.
I'm doing well, thank you.
Good.
Thank you, and thank you for inviting me to this.
Awesome, my pleasure.
Forum.
Good. So Dawn is known for treating other humans with as much empathy as she does her beloved dog Finn. Aww. Dawn Deans is driven to support business owners in pursuing their business ventures, no matter how wild or timid their ideas might be. Since 2008, business owners have been hiring Dawn to advise them on the many and varied legal issues facing their business, from startup to wind down and everything in between that might show up on the road to success. As a trustworthy advisor, Dawn's superpowers include being a keen listener with clear and thorough legal advice on business and trademark matters. Dawn brings years of legal knowledge and business experience to the conversation, with the occasional dose of dark humor thrown in there somewhere. I kind of like that. Okay, let's get started, Dawn. Good to have you again.
Thank you.
All right. Yeah, I'm sure there's been so much talk about COVID-19 and everything going on regarding commercial leases, landlords, and rent, breach of contract, or being unable to, for many business owners, it's just being unable to perform their obligations in terms of rent payments and, you know, maybe mortgage even. And so today we're just going to be going through a series of questions about what is facing business owners today. And also, I believe we're talking about employees as well and employment issues. So for anybody listening out there, it's not just business owners, it's also if you're being employed and, you know, there's been maybe any breach of contract and stuff like that. Okay, so let's kind of just dive in. Let's start with the commercial contract and leases part of things, right? So let's start with this. Does the whole crisis that we have going on right now, does it constitute an excuse for non-performance of any commercial contract?
So It'll depend. Uh, that's always a lawyer's answer. It depends. So, and in this particular situation, there's two areas of law that the legal community is considering in regards to commercial contracts. And the first place we would look for is within the contract itself for a force majeure clause. So what a force majeure clause is a provision in commercial contracts that allows for the deferral of performance of a contract during what's called a force majeure event. And so it doesn't end the contract, it just defers the obligation to perform that particular obligation in the contract. However, for a force majeure event to occur, it has to be an event that's entirely outside the control of the party that's relying on it. And that event has to actually directly be preventing the party from being able to perform a particular obligation in the contract. So if we're talking about paying rent, rent will almost never be deferred by a force majeure event. It would be more of the types of situations where, let's say in a commercial lease, where a tenant is obligated to keep their doors open. It's like a retail location, and they're required to be open during certain business hours, certain days of the week. Well, if the government has ordered a business to close its doors, then that's one of those type of events that could fall potentially under a force majeure event. And all it would do is defer the obligation to have the doors open during those timeframes so that the tenant wouldn't be in breach of contract. However, in a force majeure clause, there tends to be notification requirements and ongoing obligations with respect to advising the other party as to when the force majeure event has ended, and getting back to the contract as soon as possible. So that's one avenue that's available, and force majeure clauses can be found in all sorts of commercial contracts. It's not just a lease. In fact, leases, they're sometimes in there. They're very often in like a franchise agreement. So if you have a franchisee, very good chance there's going to be a force majeure clause in that type of an agreement. In supply agreement, so if somebody's supplying services or goods, they'd want to look for a force majeure clause in their contract.
And that's if the contract is done right, right?
Yeah, right.
In the first place.
Exactly. That's assuming that you have a well-written contract, and every force majeure clause can be different from each other. So we'd be looking at the language in that particular clause because it's a purely contractual legal avenue. It has to be in the contract. Rarely will a court imply a force majeure clause into a contract. So it has to be expressly in there. And it's going to be the language in there. What type of events did it contemplate? And what does it allow in terms of deferral? And so those are the things that somebody wanting to rely on that clause would need to take to their lawyer, have it reviewed, and get specific legal advice before acting on that force majeure clause.
Let's talk a little bit about deferment here, Don. I mean, with this type of COVID-19 situation where there is actually no end date that we know of in terms of how long things are going to last, how long businesses have to close and stuff like that. What does deferment mean here? Is it an open-ended deferment? Is there a possibility of an open-ended deferment, or will there be like an
sometimes there is. Sometimes the force majeure clause will be written that for so long as the event exists, that the obligation will be deferred. Other times there is a cap on the amount of time. So if you reach that cap of the number of days or weeks or months or whatever it is, and you get to the end of that, then there's usually some other opportunity either to terminate the contract or whatever. It's usually termination, if depending on the type of contract that it is. So the key point though is that it doesn't end the contract. It just defers that particular obligation, and it doesn't necessarily defer all obligations under the contract. Because like I said, a force majeure event does not make paying rent, even if your doors are shut, it doesn't make the obligation of paying rent impossible. You can still pay rent, even if it's a financial hardship for you to pay rent.
Right.
It's not an impossibility for you to pay rent. So, and usually force majeure clauses will actually exclude payments that are owed. So whether it's royalties under a franchise agreement or rent under a commercial lease, that's not the type of obligation that will be deferred. It's only other types of performance within the contract that's deferred. So that's important for, let's say, a commercial tenant, if they're, thinking to themselves, well, I can't pay rent because my business is shut down. Force majeure isn't going to help you. That's not it.
So let's talk about that in terms of financial hardship and things that business owners might be facing as a result of being closed. Obviously, for most business owners, we are assuming that a source of being able to pay rent is their business actually running. But we've established that force majeure may not necessarily cover you, from paying rent. So what's the best course of action here in terms of making sure that you aren't like breaking the terms of your contract? Would it be to, to talk to your lawyer, to talk to the owner, the landlord, or whatever? What's the first course of action that you should be doing, instead of just saying, you know what, I can't pay rent, so what am I going to do? You know what I mean?
Exactly. Yeah. And generally, the advice we're giving is talk to your landlord. Keep communication open. Most landlords, from what I'm hearing back, is that most landlords are being reasonable and are trying to work with their tenants. The reality is, for a landlord, is that even once doors are reopened, the economy is going to be suffering, and finding a new tenant is not going to be an easy task, right? That we're going to be in a downturn in the economy, and keeping a good tenant is important. So that's key. So really, open communication is the best advice I can give. There's things that are being done in terms of rent deferral, tacking it on to the rest of the lease, either at the end or over the rest of the lease once rent does start paying. I've heard of people who are having the basic rent deferred, but then are paying like the common property type of rent that gets paid in some types of leases. I have heard of landlords not acting reasonably as well. So there is that possibility. Your landlord may say, no, the rent's due and it's due. So, but from my perspective, if I was advising a landlord, I would be advising to act reasonably and to try to negotiate a rent deferral with your tenants, because I think after this is over and the courts are reopened, because right now they're closed down, so other than to emergency court actions. So I don't think the courts are going to look kindly on landlords who acted unreasonably, who didn't try to negotiate some type of rent deferral. So I think that's in the tenants' favor in terms of trying to negotiate something with their landlord. Is that
but what
there
if
is
not being reasonable? Like, I mean, you mentioned that the courts would not be kind to them after this is over, but in the meantime, if your landlord is not being reasonable, what should the tenant be doing?
Right. So therein lies the problem, is that in order to evict a commercial tenant, a landlord should be getting a court order to do that. So it depends what the lease says, but even with a lease that allows you to do it without a court order, most lawyers would recommend that you still get that court sanction to do an eviction. So proceeding without the court order is risky for the landlord. And so generally, I wouldn't be recommending a landlord just proceed on their own without getting some type of approval. There's also notice periods required within a lease. So because a breach of a lease that's based on failure to pay rent can be easily cured by paying the rent. It's one of those types of breaches that, while it is a material breach of a lease, it can be cured quite easily. Therefore, there are notice periods that's required that the landlord would need to comply with. So just going and changing the lock on the door isn't going to be a great way to deal with it as a
Yeah.
landlord. And again, like I said, it's not in the landlord's best interest to be evicting a tenant under, may have a really hard time replacing that tenant.
I mean,
So
I feel like we're already kind of broaching into my next question, and I want you to keep talking about it. I just want to make sure that we're covering the bases on it, which is, can my landlord evict me if I'm not paying rent or if I breach a commercial lease in this time?
technically, yes.
Okay.
Yes, they can.
Okay.
It's a contractual obligation. If you don't pay your rent, yeah, you're in breach of your lease.
Right.
But we don't know how all of this is going to play out in the courtroom after the fact, because this is unprecedented. We don't have any type of case law to really rely upon with any certainty, with any real certainty. And so any advice that we give is based pre-COVID
Right.
case law. So we just don't know how it's going to pan out. Now, what I can say is that the federal government's coming out with a commercial rent relief for commercial tenants.
Awesome.
I checked this morning and I didn't see anything saying that it's actually been implemented yet. But so it's the federal government offering the program, but it has to be implemented through the province. So it'll be at the province level that you would receive the relief. It is taking them, we're already well into April here, and they still don't have it going. So hopefully they get on this soon, but that could be a lifeline for a lot of commercial tenants in terms of being able to stay on top of their lease and not let that go into a breach circumstance. So that's what I would be looking to if you're really struggling with your lease. If you have a landlord who won't negotiate with you, certainly keep your eyes open for the government programs, because that's going to be critical, I think, for a lot of tenants.
So you mentioned, Don, that you haven't seen, because this is an unprecedented situation, you haven't seen court cases that kind of back what's going on here. I feel like maybe for the next pandemic in 100 years after this, there might be a number of court cases that
exactly
might be helping the next one, hopefully. Okay, so what do you recommend for like, what recommendations do you have for commercial tenants at this time? What do we need to be thinking about? What do we need to have in front of us, basically?
Yeah, so I think having, if you're unable to keep your doors open because of a court order, then if you are going to rely on a force majeure clause, assuming your lease has one, you need to take a look at what the obligation is under that force majeure clause is, because there are going to be notification requirements in it, and you need to comply with the provision in order for it to work in your favor. So that type of breach needs to be dealt with that. If it's rent that you're concerned about, you got to talk to your landlord. You got to do your best. And if you're having trouble with your landlord, I strongly advise you reach out to your business lawyer and get some help. You might be able to get a negotiation going if your lawyer can advocate on your behalf and explain to the landlord why it's problematic for the landlord to not try to be reasonable during these times. I do think that's the best scenario. Obviously, a tenant having a hard time paying rent might be reluctant to start incurring legal fees on top of that, but in the balance of things, it's something to consider, and to hopefully you already have a business lawyer in place that you can talk to and run things by. Like I said, I'm also offering a free half-hour consult. So this would be one of those type of topics I'd be happy to talk to somebody about, just to give them some options as to what they can do.
Yeah, and I mean, I know that, of course, as business owners, we are cutting costs as much as we can and cutting budgets, but I think it's a balance, right, of what you could possibly lose from not taking action, like consulting a lawyer and stuff like that. So sometimes it's necessary, it's just plain necessary to throw the budget where it needs to go so that you can protect what you have, because being thrown out, even for whether it's for residential or commercial purposes now, being thrown out because of this situation is probably in the long run much worse than not contacting a lawyer. Not to make landlords look like the bad people, right? Like the ones
Right,
that may
right.
or may not be reasonable. Let's talk about from the landlord's point of view. What recommendations do you have for landlords too? Because I mean, they're human. This is their own source of income as well. So we need to
Right.
consider that, right? It's their own source of income. Having their tenants not pay rent is going to cause financial hardships for them as well. So what
Exactly.
recommendations do you have for commercial landlords at this time?
Right. So that is the other side of the story, is that a landlord also has financial obligations that they need to meet in order to keep their building. And if they fail to pay their mortgage,
Yep.
they're going to be foreclosed on. So that also goes to the landlord in terms of having a discussion with their banker or their lender in regards to the financial obligations of the building, and either getting deferrals or renegotiating terms on that mortgage. And that should be done as early as possible. And obviously, it's going to depend on the relationship that the landlord has with their bank and how good that relationship is. So, but that certainly is something that they should be looking at and trying to get in place as soon as possible. And really, preferably before they start negotiating with the tenant, having an understanding of what freedom or of change that they have in their lending situation, so that they know how much they can work with their tenant in order and still stay afloat.
Right.
Because yeah, you're right. Everybody's going to be suffering through this, and this is why we're advising that everybody needs to be trying to act reasonably.
Right.
Act reasonable in these unreasonable times.
Right.
So that is kind of the mantra being thrown out there to do that.
Yeah.
So kind of one of the next areas, so we discussed about excuses for non-performance of commercial contracts, and leases are certainly one of the big ones out there that tenants
That's
are
right.
concerned about. But there's also other types of commercial contracts like supply agreements. So people who supply goods and services to other businesses or to consumers. And so when force majeure is not available, there is another legal doctrine called the doctrine of frustration.
Okay.
And the
I
end
love legal
result,
terms.
I know.
I almost want to laugh at that. That's amazing. Doctrine of frustration.
Frustration. And yeah, are you frustrated? And that's not what it means. What it means is
Okay.
that the purpose of the contract is frustrated to the point of where it can't be performed, or that the purpose of the contract has been so altered by this frustrating event that the purpose no longer exists. In the COVID context, what it means is that that the purpose of that obligation in the contract becomes an impossibility or an illegality. So again, if there's been a government order preventing something from happening, or if due to transportation and supply logistics, it's become an impossibility to obtain the goods that the supplier is required to under this contract, frustration might apply. And it's not a contractual term. It is something that's based purely on case law and common law, and would need to be looked at by your lawyer because it's very fact specific. It's also going to be based on the length of the contract, how long this impossibility goes on. So how long the COVID lockdown continues to exist, and how much that directly is impacting the impossibility of actually performing. That will determine whether or not frustration will apply. Because in a frustration situation, it's not a deferral of the obligation. It brings the contract to an end. It discharges both parties' obligation to continue to perform that contract. So it ends the contract. So in a lease situation, probably not going to apply because it doesn't really make sense. But it's more in the type of supply agreements where time is of the essence. Somebody needs these goods in a certain time period, and so that's an actual term in the agreement. Time is of the essence, and it could bring a contract to an end, and therefore relieve the supplier of the obligation of providing the goods. This would be true in a distribution agreement as well, where somebody distributes products out to other parties. But if they're prevented from doing so, let's say it's a non-essential business and they have to cross the border and they're not able to do so, do it because it's not essential, it's a non-essential business and it's provision of services or something like that, then you know, that's what we would be looking at is it an but it has to be an impossibility and directly linked to the obligation that's required. So it's a really high bar to meet that, but under these particular circumstances, we don't see frustration a lot being invoked or upheld, but these are unique circumstances. Yeah, these are very special circumstances, and it is something to consider and to have a discussion with your lawyer if you're finding that you're in some type of a contract that requires you to do something, but it's either become court ordered or government ordered that you can't do it, or it's just become impossible. But it does have to be impossible, not just difficult or onerous or financial hardship on you. It has to be an impossibility. So that's why I say it's a very high bar.
Right. Sorry to cut you short, Dawn. Let's talk about another impossibility, which might be a funny situation here, because we've talked a lot about people that have contracts in place. What happens when people don't have contracts in place and they're still facing all of these issues that we've talked about? What should they be doing?
Boy, that's a tough one. And it happens more often than you'd think, where there's just a verbal agreement. And in that case, it really would come down to one, definitely needing to speak to your lawyer to review what the intentions have been up to this point, what the facts are around that verbal agreement, and what your obligations might be. Frustration might apply in that situation, but that would be very fact dependent and would really need an analysis of all the facts, the situation, and why the person's not able to perform that contract.
Okay, so there's still an option for people that don't have contracts, basically, right?
There is. It's not great. It's not a great situation to be in. Just because it all comes, there's nothing in writing, therefore, or maybe very limited terms in writing, like through an email, where people have agreed something by email. So you have a few things in there, but yeah, so then it's just going to come down to what's the custom been up to that point, and then what does the case law say relating to that. And like I said, we're living in unprecedented times, so it could be hard to give any definitive answer. So there'll definitely be risk going into that situation and trying to give any clear guidance on that.
Okay, absolutely. I just want to reiterate at this point, because we're certainly talking about people with no contracts, that basically any information that we talk about, anything that we talk about during this conversation is only general legal information. It's not intended to be relied upon. So you want to consult with your lawyer. You want to make sure that you are in the right books, basically, and there's no solicitor-client relationship that's being created through this conversation. Just needed to say that again because of that question of if people don't have any legal contract. Okay, so let's move from talking about commercial leases and agreements and stuff like that to employment issues here for people that are employed or employers of labor as well. Now let's talk about being laid off or laying employees off during this time. Can an employer just temporarily lay off employees during during this quarantine period, or whether it's temporary or permanent? Actually, is there a thing?
Right. So under BC law, there is no such thing as a lawful temporary layoff. It's it would be considered constructive dismissal. So termination of employment, that's under ordinary circumstances. We are hearing a lot of, and the exception to that though, is that if an employment contract allows for a temporary layoff, or if the employee agrees to it. So in either case, the employee has agreed to it at some point, either at the beginning of employment or in the course of employment. under the current situation, if a business has had to close because of public health requirements, our feeling is that the temporary layoff situation is going to be viewed somewhat differently than it would have prior to COVID. However, that's only if it's directly related to a public health issue. If it's just because it's easier for the employer, then it will be termination. Depending on whether you speak to a lawyer, an employment lawyer who represents employers versus employees, you're going to get a slightly different viewpoint on that. But the law is clear that any change in employment terms, whether it's not paying the employee or not having work for the employee, is that those are essential terms of an employment contract, whether it's written or verbal, and that a change to that is potentially constructive dismissal. So what that means is that for an employer looking to temporarily lay off, again, open communication between employer and employee. It's really important right now that we all try to work together and figure this stuff out together. For a business that's being directly impacted by the quarantine, who's had to shut its door, there may not be any other option for that employer.
Right.
Therefore, the employee should be seeking employee benefits through the government. They are available and should certainly be taking that course of action in the short term. Employers should also be aware that even if your employee agrees to that temporary layoff, so you're falling under one of those exceptions away from constructive dismissal, that the employment standards does say that if you're not paying wages or benefits during that time, then after 13 weeks, it's deemed a termination of employment. Okay. And all the obligations of termination arise, such as severance and all of that. So the temporary means temporary. This isn't an indefinite layoff that the employer gets to decide when and if the employee is going to come back. If you reach 13 weeks, it's now deemed a termination, and severance is going to arise in that situation. So that's really one of the key things, I think, employers who are thinking about temporary layoff until the doors open back up, and all of that. So what we're seeing a lot are employers a lot of employees are working from home. That's so you can keep them employed, keep them working, and not be worried about dismissal and severance and all of those financial obligations that arise with terminating an employee, and to keep your business afloat and all of that. There's just a lot of practical considerations within there. But for an employer who's just seeing this as a good time to get rid of employees, they need to tread cautiously, because employment standards still apply. Employment laws apply, as do the human rights legislation still applies. And in fact, the Human Rights Tribunal has come out with a statement. They have a video on their website that essentially says human rights is even more important right now, because COVID is actually considered, because there is a stigma associated with it, it is considered a disability. If you have an employee that is diagnosed with COVID, that is a disability that has to be accommodated. And so those are the types of employer issues that employers should be seeking legal advice from an employment lawyer with respect to, if before they start making any decisions like this, of how to handle it, and what are their legal obligations to their employees, and how to manage those risks. Because again, these are unprecedented times.
That's true.
Legislation still applies. However, how it's going to be applied in terms of, let's say an employee is considered to have been to be under a constructive dismissal because the employer didn't have to lay them off. They weren't government ordered to shut their doors. It was just easier financially to lay them off. That's going to be a constructive dismissal, even if you don't call it that, a termination. And but what's the severance going to be from that? Because there's the legislated severance, but there's also common law or case law based severance, and that's very fact dependent on the nature of employment, how long the employee's been employed, how old the employee is. Those are all the type of factors that are looked at, and so it could very well be more than just the basic 2 weeks notice, 3 weeks notice,
right.
or payment in lieu. There's also another area of severance that could apply in this situation. So it's really important for employers to get legal advice before acting in that. And then if an employee's been laid off, they may want to consider also getting legal advice with respect to what their rights are.
Their rights are, that's right.
Yeah. And BC government, the Employment Standards, the Ministry of Labor website has really good information there in terms of what are employees' rights, what are employers' obligations. That's a good place to go to start, to get a general understanding of what those obligations are and what your rights are as an employee, so that you understand if something hasn't been done properly.
And I want to mention at this point as well that after our conversation today, Dawn has shared a couple of links that are helpful, and I believe, Dawn, that's part of the ones you were mentioning from the employment standards, yes, employment information, that I'll be kind of putting on the screen for you to see, and you'll be able to access as well. I think they're like 5 different links here that I'm looking at, and they'll be very good source of information in detail as regards to what you should be looking at. Don, you talked about working from home now as an option that, of course, many employers who are able or embracing to make sure that, one, your business is staying afloat, to keep your employees working as well, and kind of just keep things going on as much as we can. There's been a lot of talk and arguments about how this might be the future of work, that people will begin to realize that employees can actually work from home. So in the light of that, if I was an employee that am not working from home and I'm doing my job, after all of this is over, can I just tell my employer, I was being productive working from home? Can I just keep doing this? I just want to keep going and doing this. And also from the employer's point of view, what do we need to be basically looking at after all of this is over to make sure that temporary work from home does not become permanent work from home?
Well, I think you bring up a good point in that I think employers should first, before just automatically thinking, let's go back to the old way we've been doing things, I think they should look and see, was this a good change in their business? Is it a perk they can offer certain employees? Right. Obviously, it works better in some employment positions than others. You'd want to look at what the productivity was like and what some of the issues were. Are those issues that could be addressed with having certain policies in place and having more time to deal with it? Because certainly for a lot of businesses, they had to shift very quickly and figure out how to do the work from home without having a lot of time to prepare for it. But if given more time to prepare and to have computer laptops and to have all the security and things in place, that's really important, then I think that's the first step is, would this be good for my business? Would this be good for my employees to be able to work from home, even if not every day, on a partial, part of the week type of basis? Does it work for my business? Does it make me a better employer? Does it make working for me more enticing and therefore attract employees happy? And makes employees happy. And does it attract the high quality of employee? So that's the starting point for me in terms of how employers should be looking at this. I think if employers are even if employers are considering it, I think it's really important right now to have a temporary a short and straightforward work from home policy for these employees that cover a lot of different things. But certainly if you only want it to be temporary, it should say so. It should say this is temporary. It's a measure being taken to address the COVID quarantine, and that have like some type of an event that would cause the temporariness to come to an end, whether it's a lift of a government order or whatever the situation, the type of business it is. If you could put some type of trigger that will make that temporary work from home term of the employment contract come to an end. Because the issue is that you hire somebody on certain terms of employment, and because of this, there's been a change in those terms. And that would be the argument of the employee. Well, I agreed to this change of employment term, and I don't want to agree to go back to the way it was before. And so, you know, so there needs to be clear guidance from the employer to the employee of what the expectations are. So I think that's probably the best thing an employer could do. And, but I do think there's going to be a lot of changes to businesses as to how things are done, because this is the first pandemic we're dealing with, but who's to say there won't be others? And there's other types of events that can happen that make working from home just keeps business going a lot more quickly, and having less impact. For myself, my law firm, my legal assistant works from home most of the time, and I barely noticed any of this. It hasn't had an impact on how I do business. So I'm doing it the same way I always do.
Awesome.
So it really hasn't made a
and
difference.
Don, you touched on it on a bit of, well, my next question to you was going to be there in terms of changing the policies and changing the terms of an employee's contract. So basically, I just want to reiterate and just take a step back to talk about that a little bit more. Is for many employer-employee relationship, there's already a contract in place, which of course for many people didn't include anything like when there's COVID-19, this is what we're going to do, because nobody knew what's going to happen. So there's a lot of, probably a lot of scrambling to develop new policies and stuff like that. So are you saying there is that opportunity to modify such contracts because of this that is happening, which we haven't seen before? And then, you know, do we want to modify it after, or just kind of like you said, put those triggers in place for after this is over, then this is what we continue to do, and, you know, etc. like that?
Yeah, I think under these particular circumstances, a modification of the workplace will be an acceptable change of term of employment, especially if you are keeping your employees hired, you're paying them, and their work hasn't had to substantially change, but it does have to be directly related to the COVID crisis, and not just because.
Yeah.
So unless the employee agrees. If an employee agrees to a change of term of their employment contract, it's fine. But if an employee doesn't want to agree to it, then that's where the problem can arise, and the employer would need to seek legal advice on how to deal with that, because it would be, again, very fact specific. But yeah, it's, I think under these unusual circumstances that doing something that helps an employee stay employed is going to be an acceptable change of the term if it's directly related to the COVID.
Okay. So, but then issues arise with working from home, like a lot of privacy issues, trade secrets, because probably company computers are being taken home, company trade secrets, confidential information are being taken outside of the work environment. So how do you advise, what do you advise employers to be doing in terms of protecting their trade secret, protecting all their confidential information while employees are not working on their premises?
Right. Yeah, it's a huge issue. The privacy issues, both customer privacy, company information privacy, as well as employee privacy, are all big issues with the work from home, especially, like I said, because so many businesses have done it on such a quick turnaround without having the ability to do a lot of planning for it. So what we're recommending is that employers come up with again, a work from home policy, an employment policy, and specifically work from home policy that covers all the practicalities of an employee working from home. So some of those types of issues would, one, having a clear outline or defining what the employee's responsibilities are.
Right.
So you really should have that anyways, but a lot of employees are hired without a written contract and they just know what their responsibilities are. Well, that can look quite different when you're working from home. And so having a clear written list of what those responsibilities are will be important.
Mm-hmm.
And they should stay in line as closely as possible with what their previous responsibilities were. Changing an employee's responsibilities, it could be problematic. So trying to stay close within as it would apply in a work from home environment. But then there's also, what's the employee's responsibility or role in protecting the company and customer information while working from home, having guidelines with respect to that, how to secure the remote workspace. So we have several people working from home in the same home and several computers floating around. We've got kids, we may have other adults coming in and out. Homes can be widely various to how many people are living in that home.
Yeah.
And so it's really important that company information and customer information is being protected. So whether that's on a computer or flash drives or cell phones, whatever format that this information is being stored on, it or paper, it needs to be secure and it needs to be protected and not open to disclosure to other people in the home.
Okay.
And so there needs to be policies in that written work from home policy as to what that should look like. Other thing is security. So having either establishing or updating security protocols with respect to the computer, updating firewalls, password protection, all of those types of things that keep the information on a computer or device secure there needs to be clear guidelines of how an employee can comply with respect to that. You should probably have that anyways, but if you don't, if a business doesn't have it, they for sure should have it if you have employees working from home. And then a breach reporting requirement. If an employee is aware that a breach has happened, having a set step of what that employee needs to do in terms of notifying the employer and whatever else, possibly having a note, although usually you have a manager notify a customer if there was customer information. But timeliness is really important in terms of the breach reporting.
That's right.
Because there's legislation that governs that. Also, it's best if you can require an employee to use a company laptop or VPN or secure network versus their personal computer. Personal computers can be quite vulnerable because we do a lot of other stuff on them, and prohibit employees from downloading and storing company documents on personal devices, as well as using personal email to transmit company information. Personal email can be quite vulnerable as well. And then in terms of storing company information in the cloud and customer information, only allowing that to be done through company approved platforms for doing that. There's lots of them out there. Some are better than others, and the company should have established which platform that's going to be, so it's not willy-nilly just all over the place. You want to know where all your company information is being stored, and preferably having a platform that other people with access privilege can access it as well. So it's not
they can
solely
within time.
So it's not solely within the employee's accessibility that the employer can also access it. And then requiring employees to conduct telephone and conference and Zoom calls, video calls in a private room in the home, wherever possible, outside the hearing and viewing of other people in the home. And then just reminding and having a policy for employees with respect to the risk of malicious email ransomware, things like that. Those are, to me, ransomware is one of the biggest vulnerabilities of having a company computer and information completely locked down. So that work from home policy just needs to cover, really,
it needs to be
pretty much common sense,
yeah,
but it needs to be
extensive.
extensive. It needs to have very clear guidelines, steps to take if something happens, and clear expectations of how to protect company information and customer information.
Right.
And then, so that's really, I would say, one of the other things. Often in employment agreements, there's also in written employment agreements, confidentiality provisions in there. Right. Those would apply, still continue to apply in these situations. If you don't have a written agreement, you might want to throw in a confidentiality provision as well. And just to reiterate to the employee that all this company information is confidential and not to be disclosed to third parties.
Okay. Awesome. So as we round up today, Dawn, have there been other things kind of like maybe we've not touched on that you've seen in the last, is it like, I think we're on like the 6th week of all this craziness
losing track of time. Huh?
I am losing track of time. So definitely. But about the last 6 weeks, have there been other things that we kind of haven't touched on that you've kind of seen in the industry that you want to just talk a little bit about?
Well, just briefly, that if let's say a landlord or employer, or I think those are the two most common scenarios, intends to enforce their rights, not directly because of COVID, but because they were going to anyways, just to be careful right at this time, that using COVID as an excuse to terminate a lease or to let go an employee is going to be risky right now, and that there needs to be a solid basis for doing it, and having an understanding of what legal obligations are in those type of situations. I have spoken with people who, it seemed to me, they were the commercial tenant. It seemed to me the landlord was acting very unreasonably and wanted to terminate the lease and wasn't willing to negotiate. And I just think it's risky taking a step like that, everybody's going to be required to act reasonably in these unreasonable times, and that we all need to try to cooperate and work together and collaborate to help each other make it through this economic downturn.
Absolutely, absolutely, I agree with that. Thank you so much, Dean. Thank you so much, Don. I think my bad. Thank you so much, Dawn Deans.
Thank you, Caroline.
So I've been talking to Dawn Deans of Kickstart Law, and she has gracefully shared some resources with us, and I'm going to be putting on the screen now. So resources as it works, Safe BC Health and Safety link there. There's a BC Employment Standards information. I think there are about 3 links to that. And then she mentioned, she touched on Human Rights Commission earlier in the conversation. So if you want to check on that as well. If you want the link sent directly to you, and you're watching live on Facebook, just put a comment in the comment section saying, I want the link sent to you, to me, and then I will be able to get those to you. For everyone that registered for the entire Talks to the Expert series, you will be getting all of this in your email, as you would be getting the same from all the speakers that are participating in this series. Dawn Deans, thank you so much for your time today. Like I said, she will be offering a 30-minute complimentary consultation for questions specifically related to COVID-19, and you can reach her at hello@kickstartlaw.com. Is that right, Dawn?
Yes, that's right.
Okay, perfect. I will stop sharing that in a moment, and we'll just round off. I think it's been a wonderful conversation. There's definitely a lot going on out there, but I think the underlying theme that we've kind of touched on today is for everyone to just be reasonable. Okay. These are not things that any of us, I believe, have experienced before. They say pandemics happen once in 100 years. So probably most of us were not alive to witness the last one. So we're making history here, guys.
Yeah.
But yeah, so being unreasonable is very important. And if you have any questions, please talk to your lawyer. Again,
Absolutely.
Dawn is going to be offering 30 minutes complimentary consultation. You might want to take advantage of that, whether you have a contract in place that protects you already, or if you don't, and you know you need to get some new policies up in place, or you want to review what you already have existing, might be a good opportunity to talk to her. All right, for the 20th time, thank you so much, Dawn Deans, for coming today. Do you have any like parting words before we go off air?
Well, only a final disclaimer that
Okay.
before you act or take any legal action, talk to your lawyer. You
Awesome.
definitely need to get specific legal advice on these types of matters.
Mm-hmm.
But
Absolutely.
thank you, Caroline. I appreciated the opportunity to speak with you today.
Thank you for your time. Thank you so much. All right.
For sure.
I will see you guys later.
All right.